Yield myself such time as I may consume.
The gentleman's recognized.
Mr. Speaker, I rise in opposition to S-140. As it's been pointed out in Section 3 of this otherwise non-controversial Water and Lands Bill is the text of H.R. 986, the Tribal Labor Sovereignty Act. This non-germane provision would strip thousands of employees of their rights and protections under the National Labor Relations Act at tribal enterprises located on tribal lands. At issue is in the Tribal Labor Sovereignty Act are two solemn, deeply rooted principles. First, the right that Indian tribes possess in matters of self-local government, and second, the rights of workers to organize unions, bargain collectively, and engage in concerted activities for mutual aid and protection. Rather than attempting to balance these two important principles, the bill chooses sovereignty for some over human rights of others. I would note that approximately 75% of workers employed at tribal casinos are not members of the tribes running the casino, but this bill would strip labor rights of hundreds of thousands of these workers, as well as those who are actually members of the tribes. In doing so, this legislation would abandon the carefully drawn balance between tribal sovereignty and workers' rights that was adopted in the San Manuel decision by a Republican-led National Labor Relations Board in 2004. Perhaps prompted by litigation, the board ruled that the National Labor Relations Act will only apply if it does not impact the exclusive rights of self-governance in purely intramural matters or abrogate rights guaranteed by treaties. San Manuel decision is based on legal principles governing federal laws of general applicability with respect to Indian tribes that have been upheld by appeals courts for over 30 years. That's why courts have ruled that tribes must comply with labor and employment laws such as the Fair Labor Standards Act, the Occupational Safety and Health Act, OSHA, the Employee Retirement Income Security Act, ERISA, and the employer mandate of the Affordable Care Act. Yet this bill singles out the National Labor Relations Act on the grounds that tribes must be given parity with state and local governments, which statutorily are exempt from the NLRA. Maybe states and localities should have been considered, but statutorily, the statutes are clear that they are exempt. This is not a reason why tribes should be exempt from an otherwise generally applicable law. Furthermore, state and local governments are covered under Title VII of the Civil Rights Act, whereas tribes are expressly exempt. For employees for tribal enterprises, therefore, unions are the sole protection under federal law against discrimination, including sexual harassment, because they can negotiate a collective bargaining agreement that enforces employees' rights to be free from such conduct. Democrats and Republicans together have insisted that our trading partners abide by and enforce basic labor rights anytime we do a trade deal, and Congress has repeatedly required these obligations in trade agreements. But today the House will vote on a bill that takes away the insurance that employees have for the freedom of association if they are employed on many tribal casinos. This creates a question, a fair question. Would this legislation place the United States government in breach of any of the trade agreements that are now in effect? According to the International Labor Organization, in an opinion on a similar bill a few years ago, it would, in fact, put us in breach of trade agreements. We should be able to fashion compromises that frankly protect both workers' rights and tribal sovereignty, but what's before us today fails that test. There is no principled basis for stripping hundreds of thousands of workers from the right to join a union, negotiate better wages simply because they happen to work in a commercial enterprise on tribal lands. I urge a no vote on the bill.